Welcome to Linda Liu IP course. My name is Zhiguang GENG, and I'm a patent attorney from the Department of Electrical Engineering. Today, I would like to share some tips on the possible amendments when responding to an office action in Chinese practice. According to Rule 51 of the Implementation Rules of the Chinese Patent Law, amendments after receiving an office action should direct to the defects indicated by the examiner in that office action. But in practice, it may not be that strict. Some other amendments may still be possible when we're filing a response to an office action, and we could make wise use of it. Firstly, it is always allowed and welcomed by the examiner to make amendments for overcoming formality issues in the claims, no matter whether they have been indicated by the examiner or not. That means some formality issues in the original claims may not need to be corrected at the very beginning, but could be solved later, for example in response to the first office action, so as to save time and cost. For example, as you may know, in Chinese practice, the multi-multi dependencies need to be removed before allowance. Considering that during the prosecution, dependent claims may be incorporated into the respective independent claims for inventiveness, or may be removed in accordance to other amendments. Having the multi-multi dependencies corrected at an early stage, like via the voluntary amendments, may not be the best choice. Instead, amending the dependencies after having all the rejections on inventiveness solved would be much easier and save the time a lot. Secondly, adding dependent claims with same additional features from a preceding set of claims could be allowable, depending on the examiner's personal decision. Sometimes, in the claims for examination, we have only one set of full claims with all the desired features recited, while other sets have the corresponding independent claims only. Then, if the applicant later wants to supplement other claims with the same dependent claims, we can call the examiner and make an explanation in advance, explaining that such an adding of dependent claims will introduce no further burden for them. Most of times, the examiner would be generous enough to have this allowed, and in practice, we do have many successful experiences on such adding of repeated dependent claims. Thirdly, if the examiner has taken reference to the prosecution of a family application and there are allowed claims in that family application, we could consider amending the Chinese claim by following the allowed claims, even though amendments not directing to the examiner's rejection are included. This also needs a call with the examiner in advance, and the key is to convince the examiner that such amendments would accelerate the prosecution and save his or her time in further examinations. The above are some common cases we may encounter in practice. Hope you find it helpful. But anyway, if the applicant does want to make any additional amendments when responding to an office action, we can always try to contact the examiner first and see what we can do. We are always here at your service.